Hi, my name is Robert Blackman. I'm a patent attorney with Merrick, Blackman & Voorhees. I've been in the patent field since 1988, and today we're going to talk about the time periods that you need to take into consideration when determining when to get your application on file at the Patent Office. There's two primary time periods that you need to take into consideration. The first is the time period the Patent Office gives you for getting an application on file before you're barred from filing. And the second is how to take into consideration other activities that are occurring, such as publications, other inventors, and things like that, and how you're going to be ranked or compared to them. The first time period is under Patent Law 35 U.S.C. 102B, which basically gives you a one-year window in order to file your application. Basically, if the invention you're filing on is known or used in this country, or it's published, patented, or on sale in this country or any other country for more than 1 year before you file for your application, then you may be barred from getting a patent on your application. The second time period is a little bit more complex. It's under 35 U.S.C. 102A. As it stands now, the time period that you invent your application is the standard against which you're going to be compared as long as you fit within the other time period. So when you file an application, the patent examiner will pick it up and compare other inventors to see if you're the first to invent it, compare your application against other publications and other activities, and see whether you should get a patent. If you've invented your invention before these other activities, then you can get a patent on your application. However, there may be evidentiary considerations such as proving that your invention occurred before the filing date that you filed at the Patent Office. What the patent examiner is going to do first is compare your filing date to these other activities, the ones we discussed before, the known, in use, published or patented or on sale. And if your filing date is after those activities, you'll get a preliminary rejection, but it is possible to square behind these other activities and get a patent on your application. But as we always say, you'd be much better off if you just file before those activities occur. However, with the American Invents Act next May 2013, they're going to get rid of that, and they're going to switch to a first-to-file system. So from now on, they're going to compare the filing date that you filed your invention against other inventors and other activities such as publications, or if a patent issues or the application publishes, they're going to look at that filing date against your filing date to see who is the first inventor, and the latter inventor may not be able to get a patent on his invention. There will be some exceptions, of course. If the publication is yours, or if you work for, say, a company and it's the company's publication or co-inventor, that might not count against you. If somebody else publishes it but they got their information from you, that publication might not be used against you. And if another inventor files their invention and you can show that they actually got the invention from your publication or from you some other how, then it could be that you'll be considered the first inventor. But you can see as we go towards next May, it's going to be very important, more important even than it is now, to get your application on file quickly, so that you're the first to file, not just the first to invent your invention. If you're thinking about filing foreign, there's something called absolute novelty that you may have to take into consideration, and I highly suggest that before you disclose your invention or make it public or make your decision on when to file, that you do talk to a patent attorney, because there are other considerations if you're filing foreign or even in the US that you may have to take into account that we can't go over here. Especially if you're going to file foreign, some countries do require that before you disclose your invention that you have an application on file there, or perhaps through another system such as the Patent Cooperation Treaty, which we can't cover right now either. But we just want to talk to you about the considerations. Are basically, for most purposes, you have about a 1 year time period before the Patent Office bars you from filing an application if it's disclosed or made or known, even if it's your invention that's been disclosed or published or on sale. You basically have about a 1 year time period to get it on file. But the more important consideration is how are you going to compare to somebody else that's inventing at the same time? And the new system is going to be the first to file starting next May 16th, I believe, of 2013. Right now it's first to invent, but you need to take all this into account when determining when to file, and especially if you're going to delay at all. Thank you. If you have any questions, you can contact me at Merrick Blackman & Voigt.